I found the envelope at 7:12 in the morning, tucked between a stack of mail on the kitchen counter that Marcus had clearly meant to sort before I woke up. I was 31 years old, standing in the kitchen of the house we'd shared for 7 years, still wearing the oversized college sweatshirt I slept in, hair unbrushed, coffee not yet made. The envelope had already been opened. He'd opened it himself and then set it down too carelessly, the flap still folded back, the edge of the document inside visible. I pulled out the paper thinking it was a utility bill or a bank statement. It was a letter from a law office. The name at the top was Hargrove and Beaumont, Family Law and Custody Litigation, and the first line I read was, "Re-proposed custody modification. Minor child, Lily Renee Calloway, age 4. My hands did not shake. I read the letter twice, slowly, standing at the counter in my bare feet on the cold tile floor. Then I folded it exactly as I had found it, slid it back into the envelope, and set it down in the same position it had been. I walked to the coffee maker, put a pod in, pressed the button, and listened to it hiss and gurgle while I thought about the past 3 years of my life and what I was going to do next. I did not call Marcus into the kitchen. I did not wait for him to come downstairs and attempt an explanation. I picked up my phone and I typed a single text message to my closest friend, Jonelle Watkins, who had known me since we were 19 and had watched my entire marriage happen from 10 feet away. It said, "I need you to call me as soon as you're awake. Something just happened and I need to think out loud." Then I sat at the kitchen table with my coffee, facing the window that looked out over the backyard where Lily's little plastic slide sat in the early morning frost, and I breathed through what I was feeling until it became something I could use. That moment, that envelope, that kitchen, that frost on the grass was the beginning of everything, not the beginning of the trouble. The trouble had been building for longer than I wanted to admit, but it was the beginning of my real response to it. And my real response was careful, documented, and absolutely merciless. But to understand why a man would try to take my daughter from me, using a lawyer paid for with money I couldn't trace, and why his mother was standing outside a courtroom 7 months later whispering threats in my ear like she'd already won, I have to go back a little further than that kitchen. I have to go back to the version of myself who said yes to Marcus Calloway at 23 years old and genuinely believed, that she was making a sound decision with a good person. My name is Renata Flores Calloway. I am now 32 years old. I grew up in San Antonio, Texas, the daughter of 2 people who worked hard and expected the same from me. My mother was a school administrator. My father ran a small contracting business. They were not wealthy, but they were organized, and I inherited that. I graduated from the University of Texas at Austin with a degree in accounting, passed my CPA exam on the first attempt at 23, and took a position at a mid-sized firm in Austin before eventually building enough of a client base to go independent. By the time I married Marcus, I had my own practice, modest but growing. I paid my own rent, my own insurance, my own student loans. I was not looking for someone to rescue me or provide for me. I was looking for a partner, someone to build something with side by side. Marcus Calloway looked from the outside like that person. He was 30 when we met, broad-shouldered and easy smiling, the kind of man who remembered everyone's drink order and made people feel like the only person in the room. He worked in real estate development, mostly residential projects in the Austin-Pflugerville corridor, and he had a reputation as someone who delivered what he promised. When he introduced me to his mother, Diane Calloway, at a Sunday dinner 6 weeks into our relationship, I remember thinking she was polished in a way that made you want to impress her. She smiled at me over a roast chicken and said, "Marcus doesn't bring girls home very often." "That's a good sign, sweetheart." I took it as a compliment. I should have taken it as a map of the territory. We were married 18 months after we met, in a small ceremony at a venue outside Austin. I wore a dress I had chosen entirely on my own, without Diane's input, which she mentioned exactly once with a tight smile, and then never mentioned again in words. She mentioned it continuously in other ways for the next 6 years, but on the day itself, things were beautiful. Lily was born 14 months into the marriage, and for the first year of her life, I believed we were fine. I believed the occasional coldness between Marcus and me was exhaustion. I believed his distraction was ambition. I believed his mother's constant presence was love of family. I was wrong about all 3. The first sign that something was genuinely wrong, not just stressed marriage with a new baby wrong, but structurally, fundamentally wrong, came when Lily was about 16 months old. I was working from home most days by then, fitting client calls and tax filings around her schedule, and I had started to notice that Marcus was receiving phone calls he took outside or in another room, even when Lily was asleep and the house was quiet. Not once in a while. Consistently. Every evening, sometimes twice. I mentioned it to him once, lightly, and he said it was a development deal that was at a sensitive stage and he didn't want to talk shop in the house. He said it with the exact right amount of irritation, not too much, not too little. And I filed it away under things I couldn't prove and moved on. What I couldn't prove at 16 months, I started to be able to name by the time Lily turned 2. Marcus had become unreachable for stretches of the day without explanation. He was traveling more for work, Corpus Christi, Dallas, San Antonio, and the pattern of when he traveled had changed. It used to be project-driven, tied to site visits and client meetings that I could see in shared calendar entries. By Lily's second birthday, the travel was vaguer. He'd say he had to go to Dallas this weekend, and I'd ask which project, and he'd say the one on Maple Springs, or something equally imprecise. And if I pushed, he'd tell me I was checking up on him, and that I didn't trust him, and wasn't that its own problem? It was a pivot so smooth and practiced that the first several times it happened, I ended up apologizing. I was 31 years old, an educated woman with her own business, and I was apologizing for asking my husband where he was going. Diane was present for much of this in a way I did not fully understand at the time. She and Marcus spoke on the phone nearly every day, which I had always accepted as their dynamic. But during the period when Marcus's absences were becoming harder to explain away, Diane started appearing more. She would invite herself to Sunday dinners. She would stop by the house without calling, sometimes when Marcus wasn't home, and she would sit with me and Lily and make conversation that felt pleasant on the surface, but had an undercurrent I couldn't name. She would say things like, "Marcus works so hard. I hope you appreciate that." Or, "He carries so much, Renata. He just needs support right now." I would nod and smile and pour more iced tea and think about what she was actually telling me. I understand now. She was managing me. She was keeping me placid and self-doubting while her son did whatever he was doing, and she was doing it with the confidence of someone who had done it before and faced no consequences. Jonelle was the first person who said it plainly. We were sitting in her backyard in Buda in late October. Lily was 2.5 by then, playing in a pile of leaves about 15 feet away, and I was telling Jonelle about the most recent trip to San Antonio that Marcus had taken. The one where he'd come home with a receipt for a restaurant I'd never heard of, and a receipt for a hotel with a spa that did not match any construction site I'd ever seen. Jonelle listened to all of it without interrupting, which was unusual for her. Then she put down her glass of wine and said, "Renata, I'm going to say something, and I need you to actually hear it instead of explaining it away." I said, "Okay." She said, "He is lying to you, not about one thing, about a pattern of things, and his mother knows." I sat with that for a minute. Then I said, "I know." And that was the first time I had said those words out loud to another human being, and they felt like taking a splinter out with a needle. Painful for a second, then immediately a relief. What I did in the weeks after that conversation with Jonelle was quiet, deliberate, and completely invisible to Marcus and Diane. I started keeping a log, not a journal, not a diary, a log. Dates, times, observations. When he left, when he came back, what explanation he gave. Whether the explanation matched the evidence I could check. I noted which phone calls he took outside. I noted when his phone was turned face down in a way it hadn't been in the early years of our marriage. I noted when he came home, and his jacket carried a smell that wasn't his cologne and wasn't construction dust. Something warmer, sweeter, that I could not immediately identify but logged anyway. I was an accountant. I trusted data over feelings, evidence over intuition, documentation over assumption. And I started building a case the same way I would build an audit trail, one specific, verifiable entry at a time. The name I found first was not a woman's name. It was a property. I was reconciling our joint household account in November. Lily was nearly 3, and I found a recurring transfer to an LLC I did not recognize. The name was Meadowfield Properties of Travis County. I had access to the joint account because I managed our household finances, but Marcus also had separate business accounts that I was not on, which had always seemed reasonable given that his real estate work predated our marriage. What was not reasonable was a Meadowfield Properties transfer appearing from our joint account. $2,200 monthly, going back 14 months, to an entity I had never heard Marcus mention. I wrote it down. Date, amount, receiving account number as much as I could see it. I did not ask Marcus. I did not look it up on the joint computer where he might see my search history. I opened a private browser on my phone, and I searched for Meadowfield properties of Travis County in the Texas Secretary of State database. The registered agent was a man named Curtis Beaumont. No relation to the law firm, as far as I could tell, but the name still made something cold travel down the back of my neck. The listed manager of the LLC was Marcus David Calloway. The address on file was a street in Round Rock I did not recognize, not a business address, a residential one. I wrote that down too. I want to be precise about my emotional state in those weeks. I was not a woman falling apart in her bathroom at midnight. I was not texting Marcus demanding explanations and getting gaslit into silence. I was angry, genuinely, cleanly angry. The kind that doesn't make noise but does not lose itself either. I woke up every morning and I looked at Lily eating her cereal and I thought about what she deserved. And then I thought about what I needed to do that day to make sure she got it. Everything I did was for that. Not for revenge, though I will not pretend the idea of justice had no warmth to it. For Lily, and for the version of myself that I had slowly, almost imperceptibly, been losing ground to. In December, 2 months before I found that envelope on the kitchen counter, something happened that moved my timeline. I came home from dropping Lily at my mother's for an overnight visit, and Marcus had left his laptop open on the dining room table. I was not snooping. I was clearing the table to set out Lily's craft supplies, which I was organizing to bring to my mother's the next day. The laptop was open to an email thread, the preview visible on the screen, before I touched anything, before I read a single full sentence. Showed a name. Not a name I recognized from his work. Not a colleague, not a client. A first name that appeared over and over in the preview of the thread. A name that came with a shorthand familiarity that is unmistakable. I read enough to understand what I was looking at. Then I stepped back from the table. I did not read further. I took a photo of the screen as it was, from 3 feet away, clearly showing his open email account and the visible thread. Then I went into the kitchen and made dinner. His name came up again 2 days later in a different context, which told me the scope of what I was dealing with. Marcus mentioned in passing that he had been meaning to talk to me about the household budget for the new year, that he thought we should tighten things up a bit because he had some capital tied up in a new development project, and cash flow was going to be tight for a few months. I said that sounded reasonable, and I would take a look at our accounts and prepare a summary. He said great and looked relieved, which told me he had expected more pushback. What he did not know was that I had already prepared a summary. I had prepared it 6 weeks earlier. I knew exactly what our joint household account held, what it had held for the previous 14 months, what had left it in recurring transfers, and what the approximate total was. It was $62,400. That was how much had been moved out of our joint account in 14 months to an LLC my husband had created and not disclosed to me. I called a family law attorney on the second Thursday of January. Her name was Patricia Osei, and her office was in North Austin. And Jonelle had found her by asking a divorce attorney she knew through her own professional network for the best person she would want on her side in a custody dispute. Jonelle was thorough like that. Patricia's office was on the 3rd floor of a building that smelled like coffee and carpet cleaner, and she had a wall of plants behind her desk that seemed to be thriving without any effort, which I chose to take as a sign. I sat down across from her with a folder that contained 17 pages of documented log entries, screenshots of 4 financial transfers, 3 photographs of documents, and a preliminary search of the Secretary of State database with Meadowfield properties highlighted. I set it on the desk in front of her. She opened the folder, read the first 3 pages without expression, and then looked up at me and said, "How long have you been keeping this?" I said, "About 4 months." She said, "Is there more?" I said, "Yes." She said, "Okay, let's talk about what we're going to do." That meeting lasted 2 hours. By the end of it, I had a clear picture of what my rights were, what Marcus's likely legal strategy would be if I filed first, and what I still needed to collect before we moved. Patricia told me that in Texas, marital property law meant that the $62,000 moved to Meadowfield properties could potentially be characterized as community property waste, meaning Marcus had taken marital assets and used them for purposes outside the marriage without my consent. and those funds could factor significantly into the property division. She told me that if there was evidence of a sustained pattern of deception, which she believed the financial documentation I had already provided supported, that would matter in the overall picture. She also told me that if Marcus was going to try to modify custody, as the letter I found in February confirmed he was planning, then everything I had documented would be relevant. Everything. The timeline of the deception, the financial manipulation, the pattern of behavior. All of it would help establish who had actually been the primary caregiver, who had been present, who had been managing Lily's life day to day, and who had been absent and dishonest. 2 days after my meeting with Patricia, I found that envelope on the kitchen counter. I called her that afternoon. She was not surprised. She said, "This is actually good. It means he is going to move before he thinks you're ready." "Are you ready?" I said yes. She said, "Then let's file before he does." We filed for divorce on the 3rd Wednesday of February. I had moved Lily to my mother's house in San Antonio the Friday before, telling Marcus that I was taking her for a long weekend visit and that I needed some space to think about our marriage. He seemed to accept this, which told me he was either relieved to have the house to himself or he was playing a longer game and not yet ready to show his hand. Either way, when the process server arrived at our house on that Wednesday morning, Lily was already with my mother and I was already at Patricia's office, signing documents with hands that were absolutely steady. Marcus called me 4 times in the hour after he was served. I let all 4 calls go to voicemail. Patricia had told me very clearly that all communication from this point forward should go through her unless I chose otherwise, and I chose to follow that instruction precisely. I did not listen to the voicemails until the following day, with Patricia present, so that anything Marcus said on record could be noted and filed. The 4th voicemail was the most useful. He said, "Renata, I don't know what you think you know, but you are making a serious mistake, and I promise you that you will regret this." He said it with a very specific kind of confidence, the confidence of a man who believes he has arranged things so that he cannot lose. I would hear that confidence again, amplified, coming from his mother's mouth 7 months later outside a courtroom. The second time was not more convincing than the first. Diane called me the same afternoon Marcus did. She called from her personal cell phone, which I recognized, and I let it go to voicemail as well. Her message was shorter and considerably more deliberate. She said, "Renata, I'm not angry. I just want you to think very carefully about what you are starting. Marcus loves Lily more than anything. I hope you remember that. I will always be here if you want to talk before things get out of hand." I sent a screenshot of that voicemail notification to Patricia with the note, "She is attempting direct contact." Patricia replied within 20 minutes with 2 words, "Expected." Document. The months between filing and the custody hearing were a sustained exercise in controlled pressure. Marcus hired Hargrove and Beaumont, the same firm whose name I'd seen in that envelope on the counter. His lead attorney was a man named Thomas Hargrove, who had a reputation in the Austin family law community as someone who won by attrition, by filing motions, demanding discovery, delaying proceedings, and exhausting the opposing party's resources and patience until they agreed to terms that were not in their interest. Patricia had warned me about this exact strategy. She told me that his effectiveness depended on the other side running out of money or will, and that the solution was to be prepared for every motion he filed, to answer everything completely and on time, and to let our own documentation do the work. She told me we would not play Hargrove's game. We would play our own. Our first interrogatory response was 214 pages. Patricia filed it 3 days before the deadline. It contained our complete financial documentation, including the Meadowfield Properties transfers with supporting bank records, a forensic accounting summary prepared by a woman named Deborah Kimura, who had spent 11 years working financial fraud cases before going into private practice, and a timeline of Marcus's financial decisions and physical absences going back 30 months. Deborah had spent 6 weeks going through every joint account, every known business account, and every public record associated with Marcus's name and the names of any entity I could connect to him. What she found was not what I had expected, and it was more than what I had feared. Meadowfield Properties was the first layer. Below it was a second LLC registered 18 months earlier than Meadowfield called Stonecrest Development Partners. Stonecrest had been capitalized in part with a $38,000 transfer from a business account Marcus held in his name alone. an account that contained, among other things, proceeds from a property sale that had occurred 4 months before we got married, which under Texas law should not have been treated as community property, but which had been commingled with marital funds in the years since, which changed its legal status significantly. Deborah documented all of this with the precision of someone who had spent more than a decade finding exactly these kinds of arrangements and knew every place a person could try to hide money and hope no one looked. The total documented in community property that Marcus had moved, hidden, or commingled through these structures was $112,000. Patricia and I reviewed Deborah's full report together on a Tuesday evening in April, sitting at the long table in her conference room with the city of Austin visible through the floor-to-ceiling windows behind her. Patricia read through it twice, made 6 separate annotations in the margin, and then set it down and said, "This is a very strong report. Marcus's attorneys are going to have a very difficult time arguing that this represents legitimate business activity." Deborah's methodology is airtight. She said it without excitement, just matter of fact, which was exactly the kind of tone I needed at that moment. What I had not expected, and what Deborah surfaced on her own, without my asking, was documentation that connected Diane Calloway directly to one of the property transactions. The Round Rock address on file for Meadowfield Properties, the one I had found in my initial search, was a residential property. When Deborah pulled the deed history on that address, the property had been owned by Diane Calloway until 14 months before I found the envelope on the counter. She had transferred it to Meadowfield Properties, her son's undisclosed LLC, for $1. $1 in consideration. The legal term for this kind of transfer, when it is used to shield assets from a spouse's claim, is a fraudulent conveyance. Deborah included the deed transfer records in her report with careful annotations. Patricia added it to our interrogatory response with a separate exhibit tab labeled clearly and numbered. Diane had not just been managing me with well-timed Sunday dinners and careful little suggestions that I was failing to support my husband adequately. She had put her own name on a piece of paper to help him hide a real property asset from me. She had done it 14 months before the divorce filing, which meant she had done it while I was still in the house, still raising Lily, still setting the table for those Sunday dinners, and letting her tell me what Marcus needed. The warmth I still felt occasionally, the memory of thinking she had welcomed me, that she was simply protective in the way some mothers are, burned away when I saw that deed transfer. Not in a dramatic way. More like the last of something that had been cooling for years, finally going completely cold. I told Patricia I wanted that deed transfer in front of the judge. Patricia said, "It will be." Marcus's attorneys requested 3 delays over the following months, each granted in part and refused in part by the court. The delays were exactly what Patricia had predicted. An attempt to run out the clock, wear down our resources, force a settlement on less favorable terms. Each time a delay was requested, Patricia filed a counter motion documenting the pattern of delay and its impact on Lily's stability. Each filing added to the record. Each month that passed, our documentation grew stronger and Marcus's legal position grew more precarious because every month that passed was another month in which I had been Lily's consistent daily caregiver, and the record of that consistency was being built in real time. During this period, I will not pretend life was ordinary. I was living at my mother's house in San Antonio, which meant I had given up my independent practice space, my own routine, and the home where I had built the previous 7 years of my life. I was working remotely with my clients, keeping my practice functioning from a second bedroom in my mother's house in the Alamo Heights neighborhood, with Lily asleep down the hall each night, and my mother bringing me coffee at 9 in the morning, with the quiet efficiency of someone who had decided that the best thing she could do was make sure I kept going. My mother never once told me I had made a mistake filing. She never once said anything that placed the burden of the marriage's failure on me. She brought coffee and she took Lily to the park, and she kept her own counsel about Marcus and Diane with a discipline that I recognized as deliberate and loving. On the days when I felt the whole machinery of the legal process pressing down on me, the motions, the filings, the counter transfers, the depositions scheduled and rescheduled, my mother would set a cup on the desk beside my laptop and say, one day at a time, "Mija," and mean it with her whole chest. Jonelle drove down from Austin twice during those months. The second time, she brought a bottle of a wine we had split together at my bachelorette weekend 8 years earlier, and she said, "We're going to drink this, and you're going to tell me every single thing you found out, and then we're going to plan what comes next." So we did. Lily was asleep. My mother had gone to bed. Jonelle sat across from me at the kitchen table, and I walked her through Deborah's report. The Meadowfield transfer, the Stonecrest account, the Round Rock property, Diane's deed transfer. Jonelle listened to all of it without speaking, and when I was done, she was quiet for a long moment, and then she said, Diane did that. And I said yes. And Jonelle said, I never liked that woman. I said, I know you didn't. She said, I should have said something louder. I said, you said what you could when I could hear it. That was enough. The deposition of Marcus was scheduled for the first week of July. It took place in Patricia's conference room, which was deliberate. Patricia's territory, Patricia's environment. Thomas Hargrove attended with a younger associate. Marcus arrived in a suit that was slightly too confident for the setting. Well cut, expensive, the kind of choice that tells you a person still thinks presentation is going to save them. He sat across the table from Patricia and me, and he was cordial in the practiced way of someone who has been coached to appear relaxed. Patricia was polite, methodical, and relentless. She asked about Meadowfield Properties. Marcus said it was a legitimate investment vehicle for personal real estate holdings that predated the marriage. Patricia placed Deborah's report on the table, open to the section documenting the transfer dates from the joint account. She asked Marcus to explain the $2,200 monthly transfers from the marital joint account to Meadowfield. He said those transfers had been made in error and had been corrected. Patricia asked for the documentation of the correction. Marcus looked at Hargrove. Hargrove said they would provide documentation in supplemental discovery. Patricia said, of course, and made a note, and moved on. She asked about Stonecrest Development Partners. Marcus said it was a business entity he had formed for a specific development project. Patricia asked about the $38,000 capitalization transfer. Marcus said it had been his own personal funds, predating the marriage, properly tracked. Patricia placed Deborah's exhibit on the commingling of those funds in the intervening years. Marcus looked at the exhibit for a long moment. He said he didn't believe that analysis was correct. Patricia said she was happy to hear his alternative characterization, and she placed a second copy of the exhibit in front of Hargrove. Hargrove accepted it without expression. She asked about the Round Rock property. She asked Marcus to describe his relationship to Diane Calloway in the context of Meadowfield Properties. She asked when he had first become aware of the deed transfer from his mother to the LLC. Marcus said he didn't recall the exact date. Patricia asked whether his mother had been aware, at the time of the transfer, that he was married and that the LLC had received funds from the marital joint account. Marcus said he didn't think those two things were related. Patricia said she understood, and she made a note, and she asked her next question. When Hargrove deposed me the following week, he asked the questions I expected. Was I aware of Marcus's business activities? Had I ever reviewed the LLC filings? Had I ever asked Marcus directly about Meadowfield or Stonecrest? I answered each question precisely and completely, with the log entries and financial documentation to support every answer I gave. Hargrove was good, he was experienced and controlled, and he knew exactly how to phrase a question, to make a reasonable answer sound like an admission. But I'd spent 4 months documenting my own life in the kind of specific, time-stamped detail that makes it very difficult to suggest I hadn't been paying attention. When he asked whether I'd been aware of any concerns about the marriage before filing for divorce, I said yes. I had been aware of a pattern of financial concealment and unexplained absence going back approximately 28 months, and I had documented that pattern because I believed it would be relevant. He looked at me for a moment, and then he asked his next question. The custody portion of the proceedings was what Marcus and Diane cared about most. I understood that. Lily was 4 years old by the time the custody hearing was scheduled, a round-faced, serious-eyed little person who liked puzzles and called her grandmother in San Antonio Abuela Lupe and called my mother's neighbor's dog Biscuit even though the dog's name was Cooper. She was the single most important thing in the entire proceeding. She was also the area where Marcus and Hargrove believed they had their strongest ground, because Marcus had filed for joint custody with primary residential custody to him, meaning Lily would live primarily with Marcus in Austin, with visitation to me. The argument Hargrove was prepared to make was that I had relocated to San Antonio outside the Austin area, which constituted a substantial change in circumstances that disrupted Lily's stability and warranted a custody modification. This argument had one significant structural problem. I had not relocated Lily. Lily was enrolled in the same preschool she had attended since she was 2.5 in San Antonio, which I had arranged before we left. Marcus had not visited her at that school once in 4 months. I had the attendance records signed in my name every single day. I had the pediatric appointment records, every well child visit, every sick visit, every specialist referral. I had the name of Lily's preschool teacher, Cassandra Ruiz, who had agreed to provide a written statement and, if necessary, to appear as a witness. I had the name of Lily's pediatrician, Dr. Armando Salazar, whose practice was in San Antonio and who had met with me at length about Lily's developmental progress and was willing to provide his clinical assessment of her primary attachment figure and caregiver. I had a signed statement from my mother about the daily routine of their household. I had a signed statement from Lily's swim instructor, a young woman named Morgan, who had been giving Lily lessons every Saturday morning for 3 months and who had never once seen Marcus at the pool. Patricia had also identified an expert witness, a child psychologist named Dr. Yvonne Threadgill, who practiced in Austin and San Antonio and who had conducted a formal developmental assessment of Lily over the course of 3 sessions and prepared a written report that concluded, based on observed behavioral patterns and attachment indicators, that Lily showed a strong and secure primary attachment to her mother and that disrupting that primary caregiving relationship would present a significant and documentable risk to her developmental security. Dr. Threadgill had agreed to appear in court. Marcus and Hargrove knew about Dr. Threadgill. They had received her report and discovery. They did not know about Cassandra Ruiz as a live witness. They did not know that Cassandra had kept her own attendance notes with observations about Lily's emotional presentation on the days following weekends when Marcus had scheduled and then canceled visits. There had been 4 of those in the 4 months since filing. They did not know about Morgan from the Saturday swim lessons, and they did not know about the one piece of documentation that I had added to our file in the final 3 weeks before the hearing, the piece that Patricia said was the single most significant thing I had brought her in the entire case. 2 weeks before the hearing, a woman reached out to me through a mutual contact. A woman who had worked as an administrative assistant for one of Marcus's development companies for 14 months and who had left that position in the spring. Her name was Geneva Torres, and she was 34 years old and originally from Corpus Christi. And she said she had heard through a colleague that I was in a legal dispute with Marcus, and that she had documentation she believed was relevant. She sent it to me through Patricia's office. It was an employment record, her own, showing that she had been listed as an employee of Stonecrest Development Partners at a salary of $4,000 per month, performing administrative duties. It was accompanied by a personal statement describing the actual nature of those duties, which did not primarily involve administration. It was also accompanied by text message screenshots spanning 11 months, including messages that discussed, in specific detail, a shared apartment whose lease was in Geneva's name, but whose rent was paid by a recurring transfer from Stonecrest's business account. The apartment was the Round Rock address, Meadowfield's listed address, Diane's transferred property, now leased and paid for by a business entity capitalized with marital funds. Every piece of this, the salary, the apartment, the text messages, the payment records, went directly into Patricia's hands, and from there into an exhibit that was numbered, labeled, and ready. Geneva agreed to appear as a witness. She was not angry in the way you might expect. She was quiet and very organized about it. She said Marcus had told her for nearly 2 years that the divorce proceedings were inevitable and imminent, and that he would have primary custody of Lily, and that Geneva would be in a position to be part of Lily's life on a regular basis. She said she had believed him until she started paying attention to the timeline of what he was actually doing, and then she had stopped believing him and started keeping her own records. She brought a folder to the meeting at Patricia's office that was, in its way, as thorough as mine. I will not pretend that reading those text messages was comfortable. Even after everything, after the log, after Deborah's report, after the deed transfer, after all of it. Seeing the specific language of those messages between my husband and another woman was a different kind of knowing than the abstract knowing I had been living with. It was physical. I read them once, set them face down on the conference table, and then I picked them up and read them again because I needed to do it twice to have it fully settle into the category of things that were real and documented and could not be explained away. Then I clipped them neatly to the back of the exhibit, and I moved on. The morning of the custody hearing was a Tuesday in September. The courthouse was in Austin, and I drove up from San Antonio the night before with Patricia, who had booked us both rooms at a hotel near the courthouse. My mother kept Lily. I called Lily before bed and listened to her tell me about the caterpillar she and my mother had found in the backyard that afternoon, which was apparently very significant, and I said good night, and I love you, and I'll see you tomorrow. And then I sat on the edge of the hotel bed, and I thought about nothing for several minutes, which is a skill I had developed over the previous 7 months, in the same way you develop any skill, through consistent practice in difficult conditions. Patricia and I had breakfast in the hotel restaurant at 7:30. She went over the witness order with me one final time. Dr. Threadgill was first, Cassandra Ruiz was second, Morgan from the swim school was third. Geneva Torres was fourth and was the witness whose testimony Patricia had not disclosed in a way that made her specific role in the financial arrangement fully clear to Hargrove. Everything had been disclosed per discovery requirements, but the full weight of what Geneva's testimony would establish would not become apparent until she was actually on the stand. Patricia had done nothing improper. She had simply been precise in a way that left room for surprise. We arrived at the courthouse at 8:45. Lily was not there. This was deliberate. Patricia had advised strongly against bringing a 4-year-old to a custody proceeding, and my mother and I had agreed. The hallway outside the courtroom was the standard type. Fluorescent lights, a water fountain that hummed slightly, a bench along the wall where people sat waiting with the particular quality of stillness that courthouses produce. Our witnesses were arriving separately, as arranged. I saw Cassandra Ruiz near the end of the hall, speaking quietly with a younger woman I didn't recognize. Dr. Threadgill was already inside with her materials. Geneva Torres would arrive separately, at a time Patricia had specifically chosen. Marcus and Hargrove arrived at 9 on the dot. Marcus was in a different suit than the deposition. Darker, more serious, the suit of a man whose attorney has told him to look like a father, not a developer. Hargrove was behind him, carrying a leather briefcase that I recognized from the deposition. A younger associate walked with them and said something to Hargrove in a low voice that I couldn't hear. Marcus did not look at me immediately. When he did, finally, it was a sideways look, brief, measuring, the look of a man checking whether you look afraid. I held his gaze for exactly 1 second, and then I looked at something else, because I did not need to have that conversation with my eyes in a courthouse hallway. Diane was there. I had half expected it, and half hoped it wouldn't happen. She was standing near Marcus, slightly apart from him, wearing a well-pressed blazer in a shade of cream that was her color, and she knew it. She looked the way she always looked in situations where she wanted to project authority. Composed, unhurried, the kind of woman who wants you to feel like the room is hers, and she has simply allowed you into it. She looked at me the way she had looked at me across that roast chicken table 8 years earlier, and for a fraction of a second I saw the woman I had originally wanted to impress, and then I saw clearly who that woman actually was and had been the whole time. And those two things existed simultaneously without contradiction. I was walking toward the courtroom doors when she stepped toward me. Not dramatically. She moved with the deliberate casualness of someone who wants the approach to look incidental. She stopped close enough that she didn't need to raise her voice. She said, in the tone of someone delivering information to a person who simply hasn't been told yet, "You're going to lose custody today, sweetheart. Marcus hired the best attorney money can buy. This is already decided." She smiled. It was a polished smile, the one she deployed when she wanted you to understand that a door was closing and she was the one closing it. I looked at her. I thought about the deed transfer. I thought about Meadowfield Properties. I thought about the $62,000. I thought about Geneva Torres, who was on her way to this building right now with a folder in her hand. I thought about Cassandra Ruiz and Dr. Threadgill and Patricia's 214-page interrogatory response, and 7 months of a documentation log that had started on a cold morning in a kitchen where I had kept my hands completely still. I said, "Is that what he told you?" I said it quietly, without heat. I held her gaze for exactly as long as it took her to register that I was not afraid, and then I turned and walked through the courtroom doors. The bailiff appeared in the hallway a few minutes after the hearing convened. He carried a folded sheet of paper and walked to Patricia with the focused purposefulness of someone executing a specific task. Patricia read the paper, made a note on her legal pad, and nodded. The bailiff returned to the door, and moments later Cassandra Ruiz entered the courtroom, followed at an interval by Morgan and then by Dr. Threadgill, who had arranged to be sworn and seated first. In the seats behind the respondent's table, I watched Hargrove note the presence of each witness. At Cassandra Ruiz, he made a small notation. At Morgan, he conferred briefly with his associate in a voice too low to hear. When Geneva Torres entered the courtroom, calm, organized, dressed in a dark blazer with a folder in her hands, Hargrove went very still for exactly 2 seconds, and then he turned to Marcus and said something close and rapid, and Marcus's expression changed in a way that was unmistakable from where I was sitting. It was the expression of a man who has just understood that the ground is not where he thought it was, that what he believed was decided was, in fact, very far from decided, that somewhere between his confidence and this morning, something had been assembled that he had not accounted for by a person he had spent several years underestimating. I had spent 7 months preparing for this morning. He had spent 7 months assuming I hadn't. Dr. Threadgill testified first, and she was precise, calm, and technically thorough in the way that made Hargrove's cross-examination go nowhere useful. She had her methodology, she had her observation notes, she had her developmental framework, and she answered every challenge with more specificity than the challenge had asked for. She established clearly and on the record that Lily's primary attachment was to her mother, that this attachment was healthy and secure, and that disrupting it in a primary custody shift would present meaningful and accessible developmental risk to a child at this stage. Hargrove attempted to suggest that her assessment was limited by the brevity of her observation period. Dr. Threadgill said 3 sessions was the standard clinical protocol for a pediatric developmental assessment of this type, and that her findings were consistent across all 3 sessions. Hargrove moved on. Cassandra Ruiz was second, and she brought her own notes. She described Lily's consistent daily attendance, described her as a child who was settled, curious, and emotionally regulated in the classroom, terms that mean specific things in early childhood development, and that Cassandra used precisely and deliberately. She described 4 specific incidents in which Lily had arrived at school on a Monday morning after a scheduled visit with her father that had been canceled, and she described Lily's emotional presentation on each of those mornings with the careful, observed language of someone who had been noting this professionally and not just personally. She described the specific morning she had asked Lily whether she had seen her daddy this weekend, and Lily had said, "Daddy had to go do something." She said Lily had said it with the flat, accommodated tone of a 4-year-old who has already processed the disappointment and filed it away. Hargrove asked Cassandra whether she had any clinical or psychological training. Cassandra said she had a master's degree in early childhood education with a specialization in child development and had been working with children aged 2 through 5 for 11 years. Hargrove said nothing further. Patricia called Geneva Torres to the stand. The bailiff announced her name, and she walked to the front of the courtroom, and she was sworn in with the composed, steady manner of someone who has decided to do a thing and is doing it. Marcus did not look at her when she walked past the respondent's table. He looked at the surface of the table, and his hands were clasped together in front of him in a way that was careful and controlled, and did not quite succeed at appearing relaxed. Patricia asked Geneva to describe her professional relationship with Marcus Calloway and Stonecrest Development Partners. Geneva described it in precise, factual terms. Start date, job title is listed, salary is listed, the entity it was paid from, the address of the office she had reported to. Patricia asked her to describe the actual nature of her duties in that role. Geneva described them. She used clear language, and she did not dramatize, and she maintained the same tone throughout, which was the tone of someone who had thought carefully about how to do this with as little unnecessary weight as possible, and had landed on plainness as the right register. The courtroom was very quiet while she spoke. Hargrove's associate wrote something on a legal pad and slid it to Hargrove. Hargrove read it and did not react visibly, which was itself a reaction. Patricia then introduced the text message records as an exhibit. Geneva confirmed they were accurate. Patricia introduced the records of the rent payments from Stonecrest's business account for the Round Rock apartment. Geneva confirmed them. Patricia introduced the timeline, which established that these payments had been made from an entity partially capitalized with funds from the marital joint account during the period of the marriage. Patricia asked Geneva to confirm the dates on the messages and payments relative to the timeline of the marriage and the divorce filing. Geneva confirmed them one by one, clearly, without hesitation. Hargrove's cross-examination of Geneva was brief and did not go well for him. He attempted to suggest that Geneva had a personal grievance that motivated her testimony, which was a reasonable thing to try. Geneva said she had provided documentation and that the documentation was what it was, regardless of her motivations. Hargrove asked whether she had entered her arrangement with Marcus voluntarily. Geneva said she had, based on representations Marcus had made that she later understood to be false. Hargrove asked what those representations were. Geneva described them. The divorce was imminent, the custody arrangement was decided, her role in Lily's life was anticipated and planned. The courtroom absorbed this with a very particular quality of silence. Hargrove asked no further questions. Deborah Kimura's financial report was introduced by Patricia with a precise summary of the key findings. She did not need to call Deborah to the stand for all of it. The report was documentary, and Deborah had prepared it in a form that was admissible on its own. But Patricia walked the judge through the key exhibits: the Meadowfield transfers from the joint account, the Stonecrest capitalization and its commingled origin, the $62,000, the total of $112,000 in documented community property at issue, and then, with an exhibit labeled separately and clearly, the deed transfer. Diane Calloway, the Round Rock property, $1 in consideration, the date of transfer, 14 months before the divorce filing, while the marriage was intact and while I was in the house and raising Lily and having dinner at Diane's table. Hargrove looked at the exhibit. He looked at Marcus. Marcus was looking straight ahead. Patricia said to the judge, "We have documented a pattern of financial concealment involving community assets, the use of a family member to facilitate the concealment of a marital property asset, and a sustained pattern of absence and dishonesty by the respondent over the duration of the marriage. We submit that this pattern is directly relevant to the custody determination, as it speaks to character, judgment, the respondent's priorities during the marriage, and the relative quality of each parent's involvement in the minor child's daily life, which our witnesses have documented extensively and which the records support in unambiguous terms." The judge asked Hargrove whether he wished to respond. Hargrove said he would reserve comment until he had reviewed the full exhibit. The judge said that was acceptable and moved on. The hearing concluded that afternoon. The judge did not rule from the bench immediately. In Texas family court, that is not the standard process, but she was specific about the timeline for her decision and about what she would be considering. What she said, before adjourning, was that the primary caregiver documentation presented by the petitioner was thorough, consistent, and well supported by multiple independent sources, and that the financial documentation raised serious questions about the respondent's management of marital assets that would factor into both the property division and the overall assessment of character and judgment in the context of the custody determination. Marcus did not look at me when the hearing adjourned. He left with Hargrove quickly, without the unhurried confidence he had walked in with. His associate was on his phone before they reached the door. Diane was in the hallway. I watched her watch Marcus walk toward her, and I watched her face as he reached her and said something close and low, and I watched the expression that replaced her polished smile. It was not the expression of a woman whose well-laid plan had unfolded as expected. It was something quieter and more permanent than that. It was a woman beginning to understand the full cost of what she had put her name on. I walked past them both. I had nothing to say to either of them that had not already been said in a courtroom with documentation behind it. Patricia's hand was on my shoulder briefly as we moved into the elevator. She said, "You were exactly what I needed you to be in there." I said, "I know." She smiled. The elevator doors closed. The judge's written decision came 6 weeks after the hearing. Patricia called me on a Thursday afternoon when Lily was at her music class with my mother, so when I answered, I was alone in the second bedroom where I worked, seated at my desk in the early fall light that came through the window at that time of day, in a warm slant. Patricia said, "Are you somewhere you can sit down?" I said I was already sitting. She said, "Then here it is. Primary residential custody was awarded to me. The judge found, based on the totality of the evidence, including the witness testimony, the developmental assessment, the caregiver documentation, and the respondent's pattern of absence and dishonesty, that the petitioner had been the consistent, engaged, and reliable primary caregiver for the minor child, and that maintaining that arrangement was in Lily's best developmental interest. Marcus was awarded standard visitation, every other weekend and 1 evening per week, subject to the condition that scheduled visits be maintained consistently, with documentation of cancellations to be provided to the court if a pattern of avoidance emerged. The judge's language about consistency was, Patricia said, a direct reference to the 4 documented canceled visits that Cassandra Ruiz had testified about. The property division was equally complete. The $112,000 in documented community property at issue was awarded to me in full as a finding of community waste, meaning the court determined that Marcus had used community assets for purposes outside and contrary to the interests of the marriage without my knowledge or consent. The Round Rock property, Diane's transferred property, the $1 conveyance, was identified in the judgment as subject to a constructive trust claim in my favor, which Patricia explained meant that the court was treating it as though the fraudulent transfer had not fully insulated it from my claim. That proceeding was continuing in a separate civil action, but the foundation was solid and the outcome, Patricia believed, was not in serious doubt. Marcus's attorneys filed a motion for reconsideration 3 weeks after the decision. It was denied. His attorneys filed a notice of intention to appeal. Patricia filed our response. 4 months later, the appeal was abandoned. I do not know exactly why, but I have a reasonable professional intuition about the likely answer. The appellate record would have required re-examining every piece of documentation that had already been laid out at the trial level, and there was nothing in that documentation that improved for Marcus upon re-examination. Every number, every date, every text message, every deed transfer, every canceled visit. All of it stayed exactly as documented. Appeals do not improve facts. They just relocate them to a different courtroom. Diane retained her own attorney sometime in the 4 months between the judgment and the appeal abandonment. This I know because Patricia received a letter from the attorney requesting information about the constructive trust claim and the civil proceedings related to the Round Rock property. The property itself, a 3-bedroom house in Round Rock that had been worth approximately $240,000 at the time of the deed transfer and had appreciated somewhat since, was ultimately settled in the civil proceeding for a cash payment to me of $165,000. Diane's attorney negotiated aggressively. Patricia was not moved by the aggressive negotiation. The final number reflected what the court was likely to award in any case, and Diane's attorney ultimately understood that and settled. I do not know what Diane's relationship with Marcus looks like now. I know from sources I trust in a general way that it has been strained, which surprises me in some moments, and in other moments surprises me not at all. When you help someone build a deception, and the deception collapses completely and publicly with documentation, the question of where the blame lands tends to circulate between the participants in ways that are not always comfortable for either of them. Diane had protected Marcus for years. She had helped him in a specific, documented, legally consequential way. Whether Marcus feels gratitude for that or resentment about the exposure it created is not something I lose sleep over. What I know is that both of them understood, from the day that judgment was entered, that there was a clear and immovable record of what they had done. It exists. It does not go away. That is what documentation is for. Marcus comes to pick up Lily every other weekend, on Friday evenings at 5 o'clock. He texts me when he is 5 minutes away, which is the communication protocol Patricia and I established, and which he follows because the alternative is documentation of non-compliance in a co-parenting log that Patricia advised me to maintain, and that I do maintain, consistently. Our exchanges are brief and logistically focused. I do not look for cruelty in his face, and I do not offer warmth. I hold Lily's hand until she transfers to his, and then I say, "See you Sunday," and I go back inside. Lily is fine. She is 5 now and very serious about her puzzles, and she has started asking questions about everything. Why does Biscuit, who is Cooper, have that name? Why does the sky change color at sunset? Why do some people live in a different house than their mom? I answer each question as truthfully as I can in terms she can use. She is doing well. That was always the only outcome I was working toward. I live now in a 2-bedroom apartment in Alamo Heights, about 6 blocks from my mother's house, in a building with a small courtyard where I have put 3 potted plants that I am managing with variable success. The apartment is mine alone. My lease, my furniture, my choosing. It is 1,200 square feet, and it has good morning light and a kitchen where I make coffee at 7:15 each morning in complete peace, with no performance, no awareness of being monitored, no calculation about what the person across the room is thinking or what version of the story is currently being maintained. I make coffee, and I sit at the window, and I look at the street coming awake. and I do not feel the presence of something I have to manage or survive. That absence, the absence of needing to survive my own home, is the thing I did not know I had been paying for until I stopped paying it. My practice is stronger than it was when I married Marcus. In the years of the marriage, I had allowed my client list to quietly shrink because managing the household and Lily and the performance of our life had taken time I used to put into professional development. In the 14 months since the judgment, I have taken on 11 new clients, 2 of them through professional referrals from Janelle's network. And I have started doing what I had put off for 4 years, building a specialty in forensic accounting for small business fraud cases, which is, as it turns out, an area where my particular combination of skills and recent personal education has made me unusually effective. Deborah Kimura referred a case to me in the spring. We have had 3 cups of coffee since then, and I suspect we will continue to find occasion for more. Janelle still drives down from Austin every few weeks. We do not always open the good wine. Sometimes we just sit in my courtyard and drink sparkling water, and Lily shows Jonelle whatever puzzle she is working on, and Jonelle makes the appropriate noises of appreciation. And the evening goes slowly in the way that good evenings do when there is nothing being concealed in them. 2 weeks ago, Janelle said, "Do you ever miss it?" Meaning, the marriage, the house, the version of life I had thought I was building. I thought about it honestly, which is the only way I know how to think about things now. I said, I miss the idea I had of it. I miss who I thought Marcus was for about the first 18 months. I miss having been wrong less expensively. Janelle nodded. She said, "But you don't miss the reality of it." I said, "No, not even a little." She said, "Good." And we sat with the courtyard plants in the early evening air, and the street was quiet, and Lily was asleep inside. And I did not feel the weight of anything I was carrying that was not mine to carry. I am 32 years old. I have a daughter who is healthy and curious and securely attached and knows her mother shows up. I have a practice that is growing in a direction that is genuinely interesting to me. I have an apartment that smells like my coffee and my plants and my choices and nobody else's. I have a clear, documented, court-entered record of what happened to me and what I did about it, and I find a particular kind of peace in the existence of that record that I did not expect but that I have come to understand. The record means I never have to argue with anyone about whether what I experienced was real. It is real. It is in a court file in Austin, Texas, with numbered exhibits and sworn testimony and a judge's signature. That morning in the kitchen, in January, standing on cold tile in bare feet with that letter in my hands, I made a single decision that governed everything that followed. Not the decision to leave, which was easy once I knew. Not the decision to fight, which was obvious given what was at stake. The decision I made that morning was that I was going to know everything. All of it. The whole true shape of what had been done to me, every dollar, every document, every conversation held in another room while I was in the house. I was going to know it, and I was going to write it down, and I was going to let the weight of it accumulate somewhere permanent, outside my memory, in the factual and unalterable form of evidence. And that decision, that cold, quiet, early morning accounting decision, was what ended with a judge in Austin saying primary residential custody is awarded to the petitioner. That is what documentation looks like when it is done with patience and without theatrics. That is what preparation looks like when the person doing it understands that the time they spend preparing is not time lost. It is the time they are building the outcome they are going to live in. That is what it looks like when a woman stops explaining herself to people who are not listening and starts explaining herself to a court of law with exhibits attached. Diane stood in a courthouse hallway and told me I was going to lose. She said it with the certainty of someone who had been managing outcomes for a long time and had never once been held accountable for it. She said it the way people say things when they believe the person they're saying it to has no real power. She was wrong about my power, because she had spent years confusing my patience with passivity. She looked at a woman who made dinners and managed accounts and raised a child without complaint, and she saw someone who could be managed. She never saw the log. She never saw the folder. She never saw the photo I took of Marcus's open laptop, or the property records I had searched on my phone in a private browser, or the name of the forensic accountant I had retained, Or the 214 pages that Patricia filed before Hargrove's first motion even arrived. She saw what I allowed her to see. That is the thing about being the person who keeps the records. You choose what people know about you and when they know it. You choose the moment. And when the moment comes, when the bailiff calls a witness name that lands in the courtroom like a door swinging open on something that cannot be put back, you do not need to shout. You do not need to perform. You just sit very still and let the evidence speak in the clear, unambiguous language of things that actually happened. The life I have now was not given to me. It was documented, it was filed, it was proven, it was won in a courtroom in Austin on a Tuesday in September by a woman who found an envelope on a kitchen counter and decided that morning that she was going to know everything. I am not going to tell you the process was easy or fast or without cost. It cost me 7 months of living in my mother's spare bedroom. It cost me legal fees I paid from savings I had spent years building. It cost me the version of my life I had thought I was building, which I had to grieve in the margins of everything else I was doing. It cost me the illusion that Diane had ever been anything other than what she turned out to be, which is its own particular kind of loss. The loss of believing you were cared for by someone who was only managing you. But what it bought me, what I walked out of that courthouse holding, was a custody order with my daughter's name in it, and a financial judgment that reflected what had actually been taken from me, and a knowledge, settled and permanent, that I had not collapsed when they expected me to collapse. I had prepared. I had been ready. And when the moment came, everything was exactly where I had put it. I do not need anyone to tell me I was brave. I was thorough. And in the circumstances I was in, thoroughness was the most powerful thing I could be. If any part of what I've just told you woke something in you, if at any point while listening you thought I know what that feels like, I recognize that particular kind of silence they impose on you while they do what they want, then leave your comment below and tell me where you're watching from. Tell me what part of this story hit you the hardest. And if you know someone right now who is making excuses for a person who stopped deserving the benefit of the doubt a long time ago, share this video, because sometimes we need to see that it is possible, fully possible, to find out everything, to build the case, to be ready, and to walk out of that courtroom with exactly what your daughter deserves. Leave your like, subscribe to this channel, hit the notification bell, because we tell stories here about women who decided that what they knew was more important than the comfort of pretending they didn't know it. A strong hug to every single person listening. And remember this. You do not owe anyone silence about what they did to you, least of all when it's in writing.